Hello and welcome to Kevin's Corner. I'm your host, Kevin Horner of Galligan and Manning. Thank you for joining us today. I figured since it's towards the end of the summer, I wanted to talk about something that probably a lot of people have just been going through. Summer is a time that a lot of people relocate. They want to go not when school is in session, or they're just making a big move. Hopefully you're coming to Texas, in which case welcome. Or even if you're not, sorry to see you go, but there's a couple of things that you need to think about with your estate plan when you're relocating. So I figured now, since this is basically the time that people are doing a lot of their moves, this is the good time to think about that. So to kind of set the tone, the scope of this, first, what I'm really talking about is relocating to another state. If you move across town, you probably don't need to change anything in your estate planning, other than maybe if you use a trust and you buy a new house, that's new property, that you might want to consider how it works with your trust, but that's just true anytime. So really what I'm going to focus on today is when you're relocating either out or coming into the state, and I'll talk even about the country later on, but excuse me. But first, here's what you should probably do. If you're relocating out or you're coming in, you want to have an attorney review the estate plan you already have in place to see how it works. Now, I know a lot of times clients don't want to hear that. Some things in estate planning, especially trust, are very portable. They work well in other states, and all states have what is called full faith and credit. It's a constitutional right. It basically says if a document is valid in one state, in theory it should be respected and work as a valid document in other states. And that is true, but that doesn't mean it's going to work well. It doesn't mean it's going to be built to fit the system of where you're living. So I like to use this example with clients. I'm admitted in Pennsylvania, and probate is very easy there. It's different. You use wills more often than you use trusts in other states because it's simple to open and you just don't have as much advantage. You go to another state, you might really want to change the estate plan. It's a valid will no matter where you go, but it doesn't mean it's going to serve you very well in the new place. So first and foremost, even if you have valid documents, you want to think about, one, does it work well in that state? And that could be for the reason I just said. Probate might be harder in one state compared to another, so maybe you want to adjust the style of your plan. It could just be that there's a different taxation. That's very common, especially if you're going north to south. You might come from or go to a place that has an inheritance tax or an estate tax, whereas in Texas we have neither. Pennsylvania has inheritance, New York has estate tax, and so on. And so you might have a plan that's geared towards that kind of tax planning that you simply no longer need. And so let's say you're coming to Texas, you might be able to make it a much simpler plan than you had in the past. Similarly, there's some things that are just very unique about the way things are defined or the kinds of documents that you're using. Excuse me. So like say, for example, in Texas, we have different kind of grades of an executor, or different grades, if you want to think of it, of authority given to the person in charge of an estate, like an independent executor, which is something you'll see in Texas documents. A lot of states don't have that kind of a distinction. You don't want to take, say, a distant will that's otherwise perfectly fine and not include all of the authorities that Texas law would give to an independent executor. You could simply update the document very simply to include that it's going to be an independent executor, and then you're in a much better position. So that's sort of one, is recognize that there's different states and you want to make sure your plan works and where you're going to live to fit that state's law and that state's issue. So that's one. It's the first reason to take a look at this. The second one is similar, but it's a bigger issue, is if you're going from a community property state to, I guess what you'd call a common law, the non-community property state. And what that means is, in some places, the owner of an asset is just simply the title owner. It's the person with the name on the account, so to speak. And in certain states like Texas, it's a community property state where if you're married, no matter what the title is, and this obviously gets a lot of complexity in the specific issue, but just generally, if you acquire something in the marriage, regardless of the title, ultimately, it's going to be a community asset. You each own half of it. That's not necessarily true in other places. So it affects how things flow in your estate because you might own things differently than you do in another state. So that's something you want to look at if you're moving either to or from a community property state. What is the actual owner of the accounts? How are things going to flow if you're using a will or trust, and so on? So that's two. The third one is those incapacity planning documents, the ancillary documents. you might want to take a look at those. And here's the reason why. Let's say you have a medical power of attorney done in, let's pick a random state in Michigan. I have no idea how they work in Michigan, but you do one there. And let's say it doesn't look anything like a Texas medical power of attorney. If you're here, you're going to go to the Texas hospital, and it's not going to be reviewed by an attorney there. It's going to be reviewed, and they're just going to pick as best they can, fitting into the rubric they're expecting, what they think that document means. If it doesn't look like what they're expecting, if it becomes difficult for them to understand, they're going to have a problem, and that's going to be very much affecting you if they can't get the medical power of attorney to work. And so therefore, it's usually a really good idea, even if you change nothing else, just to make powers of attorney, medical powers of attorney, directives to physician, which is a living will, to fit the state you're now residing on, so that there's no question, and you've given the authority that state permits, so that your needs are taken care of if you're incapacitated and someone else has to act for you. By that same token, by the way, too, is if you're not permanently relocating, but if you're constantly going back and forth between states, it's actually really a good idea to have two sets of ancillary documents. So I'll pick Texas and Louisiana just because we happen to be close. If you're constantly going back and forth to both, maybe you own real estate in both, but you're, say, a Texas resident, you can have an ancillary set of documents in Texas and then other documents in Louisiana. As long as you draft them so that they are coordinating, you can do it so you can use that state's document where you need to be. So that's just sort of an aside. And then finally, I just want to highlight this one because it's the same issues but maybe more complex, is what if you're relocating out of or into this country? Now, forget immigration, forget all of that for a second, that's its own issue. But just from the estate planning perspective, let's say you're leaving the United States. That's going to affect things like your Social Security, it's going to affect your taxation, it's going to affect that you're going to acquire property in another country that doesn't even use a rule of law similar to what we have here. And so if that's the case, you really want to make sure you have a good set of documents here that allow you to use, we'll call United States-based assets, even if you're abroad. And then you can have your own estate plan in the other country to which you're going that fits their rules as well. So it's sort of similar between the different states. You want to have something that can interlock and coordinate so that your estate plan is working properly no matter what set of laws that you have to follow. So I feel like I said a lot there, but the key point is if you're relocating, you want to have it reviewed. It may not need changed much, but it's good to make sure you know that and don't find out when the thing doesn't work. So first, you want to do it because you might have different state issues that you want to focus on. Two, you might have a whole different definition of property between common law and community property. And three, you want to make sure those ancillary documents are good, or that you have two if you're going to be constantly relocating. And four, all of those first three things I said, and then some if you're going in and out of the country, because those issues just become more pronounced where you're not even talking about American law anymore. So if you have relocated to Texas, again, welcome. And if you left, I'm sorry to see you go. But if you are here, it's definitely good to review your documents. You can certainly contact us for a free consultation to do that. I want to say thank you all very much for watching, and I will see you all again next Thursday at noon-ish at Kevin's Corner.